Greetings to the students of the DePaul College of Law and any other interested viewers. This video is the first in an ongoing series that will guide you through the legal research process and address different issues you may encounter. Whether you are a law student preparing for your legal writing assignments, or an independent researcher who is entering the world of legal authorities and needs some guidance, we hope these videos will be of some help. In this video, you will learn the basic contours of the legal research process, including how to plan your research, the types of actions you'll take when using databases and other finding tools, and how to tell when you are done. Many of the concepts that I'll discuss here are not being fully explored. If it seems I'm going through something a bit too fast, it will most likely be covered in greater detail in a future video. The goal of this video is just to introduce you to these topics. A successful legal research project begins before jumping into the databases. Before you start searching for cases, you need to do some initial planning in order to point yourself in the direction of the sources. The very first step is analyzing the facts of the problem that you're researching. Everything ultimately relates back to those facts. What type of complaint can be brought to court? What type of relief is sought, and what type of relief is possible? And what type of facts need to be proven in court for your side to win. Engaging in explicit fact analysis before jumping into the databases will provide you with some concrete terms and concepts that you can use while searching your sources. There are many ways to approach fact analysis, and the most appropriate method will depend on the context of the dispute. One potential approach that helps generate search terms is to use the traditional question words of journalism: who, what, when, where, and why. Who? The issue here is defining the parties in concise terms. Importantly, we want to know about the legal relationships between the parties and characteristics that will be legally relevant. We aren't interested in the parties' names. We want the types of terms that will show up in the cases that have rules that apply to our dispute. What? Now, what is something of a catch-all question? What is the injury? What's the appropriate cause of action? Are there any objects involved in the dispute that would affect the legal analysis? When? While the date that the underlying event took place likely will not affect the basic underlying laws, it is important to know whether the law that the complaint is brought under has a statute of limitations that has expired, or will expire. Where? The jurisdiction whose laws will govern the dispute is the most basic fact you'll need to determine, because that will tell you which set of laws you need to research. And why? Now, for many causes of actions and crimes, the party's mental state will be relevant to determine liability. Beyond coming up with a list of terms to put in the search bar, the analysis step is a good point to articulate an issue statement. An issue statement is the legal question or questions that you want to answer. Keeping your issue statement in mind will keep you on target and direct you to the relevant sources. After you come up with your issue statement, you want to take stock of what you already know about this type of legal dispute. Are you already familiar with the relevant cause of action or defense? Can you recognize an element of a claim that you can tell both sides will have strong arguments over? Based on your pre-existing knowledge of that area of the law, if you already have some, you should try to identify what sources of the law you anticipate would be helpful. With those planning steps taken care of, you can move on to what I call active research. That is, when you search the databases and indexes, read sources, jump from source to source, and similar activities. The first big decision you'll need to make is about whether to jump right into searching for the laws, or if you want to read a text that will explain the law and help you locate just the right source. That is, do you want to start with primary or secondary authorities? If you haven't encountered this idea before, legal resources can be divided between primary and secondary authorities. Primary authorities are laws created by governments, and they're what courts will consider when making their judgments. The problem is that it can often be tricky to locate the right primary authority, and you might need something to help explain the law to you before you start looking for sources that are actually the law. In that case, you'll want to begin with secondary authorities. If you already have a good idea of that area of the law, and just need to find a source that articulates a rule in a manner relevant to your legal issue, you may want to start by searching primary authorities. But if you need some guidance at the outset, I would recommend starting with secondary authorities. I will expand on both of these concepts in upcoming videos. After you've decided whether to start with primary or secondary authorities, you'll have to decide whether to search the databases with terms you came up with, or whether to find the terms that the editors of those sources already use for those concepts. Most people prefer using search bars with terms they've already chosen, which is called keyword searching, but there are also advantages to browsing the terms chosen by editors, which can be called subject searching and is done in indexes, digests, or the key number system. Another consideration when keyword searching is using connectors and phrases, commands that help the database narrow the search to exactly what you're looking for. You're going to encounter a lot of authorities over the course of a research project, and it can get a bit overwhelming. You'll need to develop the skill of quickly recognizing which ones do not pertain to your topic and ignoring them, saving the ones that look from a quick glance like they do pertain to your topic, and then going through the sources you've saved and seeing which ones are the most relevant and what they tell you. Another important step is updating your authorities. That is, using the databases to find if they are still valid law. You want to make sure that you aren't citing to something that has been overruled or overturned. The same tools that help you make sure the authorities are still valid have another important function: showing you everything that has cited the law that you're reading, which is a great way to find more relevant sources. Over the course of the research process, you're going to discover things you did not know about the law, and quite often that means you will find there is an unexpected issue that you did not notice when first analyzing the facts. You might also find that you fundamentally misunderstood the law when you started and were researching the wrong area. All of this is to say that legal research is an iterative process. You'll need to go back and refine your issue statement to reflect your better understanding. You will need to refine your search terms to better reflect how the law is phrased. Try not to get frustrated by this, because this is not starting from square one. What you've already learned will still inform how you research going forward. All things must come to an end, including the research process. You need to turn that research into an argument, and you have deadlines to meet. Unfortunately, you will never see a sign that tells you that you've exhausted your search and found everything that might be relevant. Sometimes you'll be lucky and find exactly the case you need that spells everything out for you, but more often you'll need to make your argument based on somewhat imperfect authorities that support it, and you'll need to develop a sense of when you can stop looking for more. Generally, if you find that you keep seeing the same authorities over and over after you've tried searching in different ways, that's a sign that you've exhausted your research into that issue. At that point, you want to read the relevant authorities in greater detail to make sure you aren't missing an issue that requires further research, update, and then focus just on the writing aspect of your research. If you have any questions about research strategy or locating a legal resource, don't hesitate to contact the reference librarians, either by chat, email, or scheduling an appointment with us.